Now, in this next podcast in Module 4, we're going to be looking at the concept of parental responsibility. This is really a basic concept underlying family law parenting cases. Now, in the Family Law Act, parental responsibility is defined as, in Section 61B, all the duties, powers, responsibilities and authority which parents have by law in relation to their children. Now, I guess that definition probably doesn't give you much guidance about what it actually means. But in practice, it's really about decision making for children. So, for example, if you're in a relationship, mum and dad are still in a relationship together, they will generally jointly make decisions about their children. For example, if their child is in an accident and needs some emergency surgery, they will be the people, or perhaps the one of them that is with the child at the time, who will give consent to the hospital and the doctors to perform that surgery. Now, in family law, there are two types of circumstances. So, for example, where parents have separated but they haven't actually approached lawyers or courts and there is no court order. So in that case, each parent, mother and father, has parental responsibility for the child. That is, decision-making capacity. This is regardless of whether they're still together or whether they've separated, and regardless as to whether mum or dad remarry. So that's where there is no court order. And for example, if you're advising a client, they might come into you to get some legal advice and they don't have any court orders. However, where there are court orders, there is a distinction made between parents making decisions in what we call day-to-day issues and long-term, or sorry, that should say major long-term issues. Now, the position regarding parents making decisions regarding day-to-day issues comes from this 1997 court case, B&B and the Family Law Reform Act. So looking at where parents have separated and they're each spending time with a child or children but at separate times, this case said when parents are making day-to-day decisions, they can make them independently. This means, for example, if mum has the child, mum decides, particularly for younger children, and as they get older obviously they decide themselves, what they'll wear, what they'll have for breakfast, what time they'll get up, what time they go to bed, what they'll have for their school lunch, what they might have for dinner. So what it means is that while mum's got the child, she doesn't have to consult dad about those day-to-day issues, and vice versa. While dad's got the child, he doesn't consult mum about those day-to-day issues. This case then went on to draw this distinction between major long-term issues and said parents should consult about major long-term issues. And the examples given in that case about what were major long-term issues regarding a child were major surgery, where they go to school, primary, high school, what religion they will be brought up in, if any, and they said and the like, so those types of major decisions. Now, the Family Law Act has embedded some of these concepts into it, and the Section 65DAE confirms there is no need for parents to consult on issues that are day-to-day issues and not major long-term issues. So that's clear now and is a section in the Act. Also, major long-term issues are defined in the Family Law Act, so you can go to Section 4 of the Family Law Act and you can see the definition. So it talks about education, religion and culture, health, a child's name, that could be a surname or it could be also a Christian name, and changes to the child's living arrangements that make it significantly more difficult for the child to spend time with a parent. Now, normally we call this a relocation. That is, the other parent is seeking to relocate to another location with the child. For example, from Brisbane to Melbourne, or from Brisbane to Rockhampton, from Brisbane to Thailand. Can also be an overseas location. Also in that section it says, to avoid doubt, a decision by a parent to form a relationship with a new partner is not of itself a major long-term issue. However, it will involve a major long-term issue if, for example, the relationship with the new partner involves the parent moving to another area, and the move will make it significantly more difficult for the child to spend time with the other parent. So that again is a relocation. Now these concepts were also talked about in this case of Good and Good, which was one of the first cases that was decided after some major amendments to the Family Law Act that happened in 2006. Now this case said that where a court makes a parenting order that provides for shared parental responsibility, and what they meant there was equal shared parental responsibility, decisions about major long-term issues must be made jointly, and parents are required to consult each other and make a genuine effort to come to a joint decision about those issues. So that's the position where there is a court order. And this is now embedded in Section 65 DAC of the Family Law Act. Now this is the theory that if people have an order for equal shared parental responsibility, for example, one parent must not change a child's schooling without consulting the other parent. In practice, parents will do these things sometimes without consultation, and that can lead to conflict, and then it's really up to the other parent to take the case to court, and whether they have, I guess, the time and the inclination and also the money to do that if they want to instruct a lawyer. Now, in the Family Law Act, there is a presumption of equal shared parental responsibility, and we will look in this more detail as we go through Module 4. However, in each parenting case, a court must decide whether the presumption of equal shared parental responsibility applies, does not apply, or is rebutted. So that means, what that means is that it's considered that generally parents will have equal shared parental responsibility, and they will consult each other about major long-term decisions, unless there are exceptional circumstances. The types of circumstances might be serious issues of family violence, serious issues of child abuse, or that the presumption is rebutted and is not considered to be in the best interest of the child. For example, where there is very high conflict between parents and they're just not able to consult about major long-term issues realistically. We'll be having a look at that section in more detail as a bit later in this module. So I guess generally, if you're working out negotiations or a parenting agreement in a mediation, generally parents will agree that they both have equal shared parental responsibility. The instances in which one parent will have sole parental responsibility are fairly extreme. In H&H, the court considered that there was serious high conflict between the parents. That was a relocation case. The mother was seeking to move up to Cairns. The judge decided that the parents were just in too high conflict and it would not be in their best interest for their parents to need to consult about major long-term issues, and the mother was given sole parental responsibility. Similarly, in GNC, the father was in jail for sexually abusing his older daughters of a previous relationship. The case was about the father seeking that the son of the relationship in question visit him in jail. I guess because of the abuse, the father being convicted of abuse of his two older daughters, it was considered that it was not appropriate for the parents to have equal shared parental responsibility, and mum was given sole parental responsibility for the child of the relationship that was in question in this hearing, who was a son who was aged 7. Mohammed Salah and Gastana was a family court of Brisbane case where the parents were Islamic, the father being much more devout than the mother at her admission, and there was a dispute over the proposed first name for the youngest child of the relationship, who was aged 2. The mother had proposed a name and had been using the name, for example, on all the child's records. The father objected to the name as he said it was offensive to the Islamic religion. The mother had a lawyer in the hearing. The father did not, so the father was unrepresented. The father had no evidence about why or in support of his contention that the name was offensive to the Islamic religion. The mother did have a affidavit and evidence from an imam, a religious person, who gave evidence that the proposed name of the mother was not offensive to the Islamic religion, and the court, because of that evidence, followed that line and decided that that would be the name of the child. Now, in this case, the mother actually offered for the father to have parental responsibility solely in relation to the children's upbringing. The court then made an order that generally she have sole parental responsibility in relation to all other decisions except in relation to religious upbringing, which would be the responsibility of the father. Now, I'm not sure how that order would have played out in practice, because in that case the parties were in very high conflict with quite bizarre facts. For example, that the father had pretended to be a teenager online to chat to the mother's older daughter to try and gather evidence against the mother for this court hearing. So he had exhibited quite extreme behaviour. But I guess for our purposes, that's an interesting case because it shows how parental responsibility can be split. Okay, so in the next podcast we're going to actually look at how family courts use the key sections of the Family Law Act to make decisions in parenting cases. Remember, if you have any questions about any of the concepts in these podcasts, if anything is not clear, please let me know. For example, please email me, because we will be having an in-person session in week 4 on this area of children and parenting orders, and we can look at any of those issues in more detail or clarify anything for you in the in-person session.